Hey everyone, welcome back to the channel. Imagine scrolling through Instagram one evening and stumbling upon a small business offering beautiful handmade phone cases, wallets, and watch straps. They all carry the iconic Louis Vuitton monogram. Elegant, stylish, unmistakable. But here's the twist. These aren't official LV products. They are being sold by a local vendor in Singapore claiming to have upcycled them from authentic LV goods. Sound innocent? Not quite. This is the story of how global luxury giant Louis Vuitton Malletier took on a Singaporean individual, Ng Hoe Seng, who used to run an online shop called SGHC for selling items bearing counterfeit LV trademarks. The case, which went all the way to the High Court, wasn't just about handbags or logos. It was about the value of a brand, the protection of intellectual property, and the fine line between recycling and infringing. Here's what happened. LV discovered sometime in 2022 that Mr. Ng, through his Instagram page MKSG, was advertising and selling a wide range of accessories, phone cases, wallets, straps, all bearing signs nearly identical to LV's registered trademarks. He claimed they were upcycled from authentic materials. LV wasn't convinced. They sent someone undercover to buy a few items, spending over $2,000 on 12 products. Later, when MKSG shut down, Mr. Ng reappeared with a new Instagram handle, MCraftsSG, doing more of the same. LV eventually sued him for trademark infringement and obtained default judgment when Mr. Ng failed to respond to the lawsuit. What followed was a legal process to assess how much money, i.e. statutory damages, LV should receive for the infringement. Now here's where the legal arguments get interesting. The key issue in this assessment was whether Mr. Ng had used counterfeit trademarks, which under Singapore's Trademarks Act would entitle LV to statutory damages, even without proving actual financial loss. This is especially important in cases where defendants don't turn up, like Mr. Ng. LV argued that the goods Mr. Ng sold bore marks that were either identical to or nearly resembled its registered trademarks, and that this resemblance was clearly intended to mislead customers into thinking they were buying genuine LV items. They emphasized that Mr. Ng used no alternative branding and in fact even tried to make the goods look like authentic LV products. But what about his claim that the items were upcycled from real LV materials? The court didn't buy it. Justice Deda Singh made it clear that using someone else's brand, even if the material once came from a genuine product, does not excuse you from liability. The judge found that the use of upcycled material did not negate the false representation that the goods were genuine LV products. As the court noted, once those materials are cut up and remade into other products without authorization, they are no longer genuine LV goods. They are counterfeits. On the question of damages, LV wanted the court to adopt a Canadian method, basically a fixed monetary scale based on the type and quantity of infringing goods. LV claimed $4.84 million in damages, but due to legal caps under Singapore law, they suggested the maximum allowable $2.9 million be awarded instead. The court disagreed. The court found that LV had misinterpreted the law. The cap wasn't per trademark used, but per type of goods. Since Mr. Ng used the counterfeit marks on 9 different types of goods like phone cases, wallets, and straps, the statutory cap was set at $900,000. Even then, the court didn't award the full $900,000. Why? Because statutory damages must reflect not just the brand's loss, but the flagrancy of the infringement, the benefit gained by the defendant, and the need to deter others. Mr. Ng's operation, while serious, was not on the scale of an international counterfeiting ring. He worked through Instagram, had limited reach, and there wasn't strong evidence of mass production or distribution. Still, the judge found the infringement highly flagrant. Mr. Ng used multiple counterfeit marks across various product types, ignored legal warnings, shut down and rebranded instead of complying, and stayed absent throughout the proceedings. Ultimately, the court awarded LV statutory damages of $600,000. So what can we take away from this? This case is a clear warning. Selling counterfeit goods, especially under the guise of upcycling, isn't just morally grey, it is illegal. And Singapore law offers powerful remedies even when the infringer refuses to show up in court. Justice is not stalled by absence. Thanks for joining me in this case summary. Don't forget to like, share, subscribe. I'll see you in the next video.